It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back here in the studio with FLA Law live on the radio. That is your live legal call-in talk show where every Tuesday night from 5 o'clock to 6 p.m. we are here in the studio answering your questions live on the air for your legal matters. And you say, who are we? We are the attorneys of Perenich, Caulfield, Avril, and Noyes. As you know, if you've been listening every Tuesday night, we are usually here with attorneys from our office or other attorneys in the local community answering your legal questions live on the air. And we are back here once again in the studio. It is myself, Jacqueline Bryant. I'm one of the personal injury attorneys at the firm. And I'm also here with my colleague, Lori Robinson. Lori, go ahead and say hello.
Very nice to be here again.
Yes, we have been getting you in here just about once a month, it seems like.
Yes, I think something on that schedule a little bit.
Good to have you, of course, as a special guest. Whenever we have Lori, you are definitely in for a wealth of knowledge. She's experienced in so many different areas of law that we practice in. And I guess you could call her a Jack or Jill of all trades, if you will.
In the personal injury area, yes.
Exactly. And as you know, that we touch on a lot of different things in personal injury, and workers' compensation being one of them. So that is kind of the theme for our show today. But of course, before we get into the topic that we want to discuss, which is workers' compensation, we are, of course, going to give you all the ways that you can call in tonight and reach us on the air. We want to hear from you. Of course, we want to be able to answer your questions. And even if they're not workers' compensation related questions, anything within the personal injury realm, civil litigation or trial matters that you might have questions about, or even if it's something outside of that and you want to give it a shot and see if we can help you, feel free to give us a call. The call-in number to call into the studio tonight, as always, is 727-441-3000. Again, the call-in number is 727 area code 441-3000. That is going to be the best way to get your call in and your question answered live on the air. And you also can find us on Facebook Live. So if you are a Facebook user, you have a Facebook account, you can certainly see us right now. We are streaming in the studio. You can see us and also hear us live. So feel free to tune in. If you can't find us, our page is Perenich, Caulfield, Avril, and Noyes Injury Lawyers. And as I said, we're live streaming there. So what you could do if you want to ask a question on the live stream, all you have to do is type it right into the chat box or the comment section under the live stream. And I will see them right now on the air. And I'll be able to answer your questions, or I'll pose the question to Lori, however is best, and we'll ask it right over the air. Same thing with YouTube. So if you don't have a Facebook account, but you do have YouTube, you can certainly go onto our YouTube channel. We are on there live right now as well. Perenich, Caulfield, Avril, and Noyes Injury Lawyers on YouTube. So hopefully those are all the ways that you can find us tonight. You can get your questions answered. And again, the call number is 727-441-3000. The lines are open. And we're going to jump right into our conversation tonight talking about workers' comp. Lori, of course, you can feel free to kind of let our audience know, how long have you been handling workers' compensation claims?
Well, let's see. I would say I've been with our law firm for 25 years now and practiced even longer than that.
Yes.
But I would say that probably the last 15 or 20 years, a big part of the practice has also been workers' comp. Now, as you know, Matt Noyes and I work as a team, and Matt has done workers' comp for years and years and years. And so when I started working more closely with him, I got involved with handling the workers' comp as well as all the other areas. And they all kind of dovetail, don't they? It's
exactly.
Like, that's part of why I'm glad that we do that. A lot of lawyers have kind of stepped back from workers' comp because of some of the changes over the years in the Florida legislature that have made it harder. Right. But we still feel it's important to be available to help people in any matter really that involves a personal injury. And workers' comp is a pretty common situation for people, unfortunately.
Exactly. There is a lot of overlap. And I think I talked about that earlier this month when we had Brian Caulfield here on the show. We kind of touched on it a little bit, how a lot of times we'll have clients come to us with either it's a work comp disability or it's a work comp auto. And a lot of people are confused about which benefits they may have access to or which route is the better one. And we'll touch on that a little bit today as well. But it's usually good to find an attorney who can help you with both simultaneously. Yes. And that's one of the benefits that you do have at our firm, because we can handle both the workers' compensation claim and the auto claim, or both the workers' compensation claim and the disability claim, or however it overlaps. So.
Right.
Yeah. So with that being said, let's jump into some of the intricacies that are contained within the workers' compensation system. You probably know that better than anyone that this is a complicated system at times, right?
Oh, yes. And a very frustrating one. Mm-hmm. I had a call a couple of weeks ago from a young woman, and this is so common. I mean, she was injured at her work, and she was told to go to particular doctors because in workers' comp, you are required to go to the doctors that they authorize. Right. And she was very put out with her experience, and she was ready to go, I don't want any part of this. And she had a friend who was a lawyer, but in a different area, who said, I think you ought to talk with a lawyer about this. So it was
good advice.
Mostly an informative talk with her, because she needed to understand that, with workers' comp, particularly if you've got an ongoing situation, in order to preserve your rights, you've got to follow what they request.
Exactly.
And there are lots of problems that happen along the way. The person ends up with continuing problems, but the workers' comp doctor says, I think you're fine. And the person isn't really fine. They want to send you back to work before you can. And yet, under the workers' comp system, you really, and this is where I do think people do need guidance. I mean, if everything's going smoothly, great, fantastic. And, sometimes
it does.
But many times it doesn't. And in those scenarios, it's easy to basically fall into a trap that will more or less cause you not to have the benefit of your workers' comp.
Exactly.
So it's we probably spent a fair amount of time counseling people. I mean, this young lady was, she just needed, because she was really getting ready to basically say, I'm not doing this, I'm going to go do my own thing, which would not have been wise in her situation. And so I think hopefully
definitely would have left benefits, on the table that she was entitled to.
And then you have the other problem, which is, you might say, well, I have health insurance, so I just want to go that route. But if you have, right, I mean, it doesn't make it's our crazy system, because say you just want to do that, which a lot of people do. They don't really want to make a claim.
Exactly.
But your health insurance, if it's a work-related injury, is not going to want to treat you.
Exactly. Yeah. So there's a lot of coordination of benefit issues that come into play there, as far as if that claim is still open and active. A lot of times most times your insurance company will deny it, because work comp is the proper avenue. And so it's just this kind of vicious cycle of dissatisfaction a lot of times. Like you said, we're constantly having to counsel a lot of those issues. And that's kind of one of the main things I ask as soon as I come into a workers' comp meeting with a potential new client is, what would you like to accomplish? Because depending on what you're looking for, this may go, in various different ways. But one thing that I've seen a lot for some reason in this past month or two are a lot of issues with new potential clients and failing to report their injury in a timely manner, or there's issues surrounding the reporting of the claim. So can you tell our listeners tonight, what exactly are the notice or reporting requirements under the workers' comp laws?
You must report your claim within 30 days of the incident. And what can sometimes happen to people is they'll have something happen and they think, I pulled a muscle in my back, I'm going to be okay. It's no big deal, and then not end up reporting it. Then they might go to their own doctor, and then several months down the road, it's like it's not going away, and it's like, this happened at the time, at work, and you really can't. Anything that occurs at work, you need to be reporting it.
Exactly.
So that it's on record, basically. And then your rights are preserved so that if if it goes away, great. But if it doesn't and it requires ongoing medical treatment, then you're covered. But a lot of times people thinking they're doing the right thing, they don't want to cause a problem. They don't want a problem themselves. And they kind of let it slide, but you really shouldn't. And sometimes you have with the employers, they're not thrilled necessarily.
That's true.
They're concerned about their insurance rates and this, that, and the other, and they can create sort of the feeling that they would prefer you didn't do that. But as long as you make the report, so you've told your supervisor this is what occurred, you can say, look, I'm hoping this won't be a problem, but here's the situation. At least it's now on record so that you're protected.
Exactly. And a lot of times it's gray area. Well, I mentioned it, but I don't know if there was a report, or I did say something, but I didn't have to fill out any paperwork, or she was right there and she saw it, but I didn't, so there's a lot of that going on. And some employers are better than others, and some will be very diligent and make sure that it's reported properly to the carrier. And a lot of them will not. Right. And so it's very much, the onus is on you as the injured person to make sure that claim is being properly reported in the first 30 days, as you said, right?
Oh, yes.
Yeah. And so that kind of carries somewhat into the statute of limitations issue as well, because sometimes claims come to us and they have that SOL problem as well, right?
Yes. And so what can also, of course, occur is that sometimes you may have an injury that you honestly don't necessarily connect to the workplace. Maybe you've had some pre-existing issues and you're not really sure that, and so you do treat, but ultimately your doctor says, you know what, this is going back to this incident you told me about, your private doctor. So at the moment, that it's work-related, you're going to make sure it's reported. So long as you're within 2 years of the incident, you will still be within their statute of limitation. But we're always going to say, don't let there ever be any question about it. Just be sure people know that there was an occurrence that was an injuring occurrence. And that's pretty important. We have other considerations, when people are actually in the system, you always have to be treating at least once a year. That's kind of a little separate issue from this.
Yes.
The main thing is to make sure that your employer knows. I mean, we do have a lot of cases, and we certainly advocate and succeed with cases where the supervisor did know. It may be possible to show that they were on notice, but you'd always rather not have to be concerned about that. And so if it's in a more official notification, then you don't even have to fight that battle.
Exactly. And I think that's one good thing about cell phones these days. There's a lot of text communication where maybe it was not formally reported, but we have a text from the supervisor, or from you and the supervisor, or an email showing that you had called out of work and mentioned being hurt on the job. And that is enough to really show that the employer was put on notice. And so that to me is something that you want to also be mindful of, is putting things in writing if you can. Even if you feel like, I may or may not have an issue, maybe it's going to get better, or maybe I won't need to pursue the claim. At least put it in writing and make sure it's been reported.
And like you said, in our modern world of the text on the phone, I would say that probably routinely that's now occurring with people.
Absolutely.
Because that's how you're going to notify your supervisor.
Exactly.
Absences and things sometimes. But so it's good. So that gives you the writing or an email, just something that shows that it occurred at work.
It's a blessing and a curse. We've moved away as a society from actually talking to people. Talking on the phone is a lost art, I think, but it's good because now we have actual
as lawyers, we do like
tangible evidence. So that's good. So that brings me to my next question. You kind of touched on it very briefly, but it's a very, very big topic in this realm, or this area of law, is the selection of providers. And you mentioned a potential client that you had spoken to who was not happy about the provider that had been assigned. So can you talk about that, how the doctors work, and when you can actually choose a doctor, if at all?
Right, because part of what can be very touchy, particularly if everything's for a while seems to be going okay, and so the individual never sees a reason to talk to a lawyer. So everything's going okay until now it's not.
It's not, right.
And so you can have a circumstance where you've been treating, the workers' comp doctor says that you are ready to go back to work. you don't feel you are,
Mm-hmm.
you still are in a position where you're going to have to do the best you can to follow through on that. But in the workers' comp world, there is an option, but it should never be exercised without talking with an attorney, of what they refer to as the one-time change in physician.
Yes.
And it's the thing that's wild about it. I mean, you know, over a number of years, that it used to be you could truly get a second opinion.
Right.
You know,
And that's the phrase that a lot of clients will throw out. Can I just get a second opinion?
You know, perfectly reasonable.
Yeah.
You know, it's what you would think. And it did used to be possible a pretty long time ago now. But now what you've got is this one-time change, but it is literally for the whole claim, for the rest of the duration of your care. I mean, you don't get to change, like if you're seeing a neurologist and an orthopedist.
That was my question, because that happens in a lot of accidents. Let's say we have a fall at work, and I have now injured my neck, my shoulder, my knee, my back. And so there's maybe a specialist for the knee and the different specialist for the shoulder. And I'm seeing someone else for, headaches.
Right.
And so they're all different specialties. One doctor saying one thing, another doctor saying another. I'm not happy with that other doctor. If I use my one-time change for that knee doctor, does that mean now I can't use it if I don't like the shoulder doctor?
Right. Yeah, and as crazy as it sounds,
Wow.
the answer is yes.
That is what it is.
Right. Yeah. So that's why it really is something for a person to have a consultation with an attorney on.
Exactly.
Because, obviously we'll get cases sometimes where maybe over a period of time the person thought they didn't need a lawyer. They made the change because you just made it thinking, well, let me just try this, and you don't really understand. And then you come to the attorney, and now it's like,
already done.
Very limited what we can do in terms of other care. There are some things, depending on the situation, but not in terms of having the right to get that so-called other opinion or second opinion. So very, very valuable opportunity there because it's so limited. So we try to preserve that.
Exactly right. And like you said, Lori, a lot of times people come to us later in the claim where they've already been treating, they've already seen doctors. Then a problem arises. Now I need an attorney. Well, earlier in the case, they're kind of dealing directly with the insurance adjuster, and they could express displeasure even at the walk-in clinic phase or the urgent care, and not necessarily saying, I want to use my one-time change, but I don't like this doctor. He's not doing what I think is best. Can I get a new one?
Right.
Oh, sure. The adjuster will do that, but you don't even realize that now you've exercised your one-time change.
And that's, I've had something fairly recent in exactly that scenario. I'm sure you've had it quite a bit too, because that's one of the first times the person is likely to be very upset because they send you to an urgent care.
Right in the beginning, yes.
And you might get a little physical therapy depending on the situation ordered by the urgent care. And you're like, what's this?
What's that going to do?
Yeah, and that's not the time to exercise your one-time change, because eventually you're going to get referred to an orthopedist out of that.
Exactly.
And then you'll have a better chance being treated, within the appropriate discipline.
Exactly. It's almost like clockwork. It's x-rays, medications, physical therapy, MRI, then specialists. It's like they have a checklist at those walk-in clinics, it seems. But yes, that was something that I think clients are a lot of times are very, very upset when they realize that they've already exercised that option very, very early on in the case, and it wasn't explained to them as such.
Right.
And at the end of the day, the adjusters are not attorneys. They're not your advocate. And so they're not necessarily obligated to advocate for you or explain the law to you in that way.
And they're always trying to minimize, really. I mean, that's what the other thing that happens over and over again is, you have, like the example you were giving, you might have ultimately a lot of different specialties because maybe different parts of your body have been injured. But what you complain about initially is the thing that hurt the most. So as an example, I share with you off the record that I got a little puppy, 4-month-old puppy, and I put up this puppy gate.
Say RJ? Is it?
Yes, little RJ, Ricky Jr., and then Nat gave him the nickname, which I love, of RJ. And I managed to catch my left foot on this little puppy gate and fall and fall on my right knee. And thank goodness, it did not turn out to be horrible, but it did, it reminded me to not ever do that again. That was very stupid.
Falls are not good.
But initially, it was my right knee that was sore and was bothering me. Yeah. Well, that seems to be fine now. Now I have just a little bit on my left foot where, Matt said, Laura, you're limping. Well, it's nothing bad and it'll go away. But I think I kind of slightly sprained it. Right. So in that scenario, if this had been workers' comp, which it wasn't, this was at Lori's house, but if it was, and I had only talked about the knee, because that was the major thing that was bothering me.
Of course.
Then when that seemed to be a little better, and I'm saying, oh, and by the way, my left foot, you didn't report that.
There you go. That's a big issue in the work comp system is what did you report initially? Because that's usually all they authorize.
Yes.
And if you didn't mention the foot, it's a fight sometimes to get them to authorize it, although you could see how it could naturally be connected.
Absolutely.
The doctors will say, well, I'm not authorized to treat that foot. So that becomes an issue that you have to call us about to try to assist with. I do have a question here on Facebook Live in the comment section from Jake, who says, what if the work comp carrier won't set a doctor's appointment? Can I go on my own?
Well, ultimately, it's a little bit of a complicated area as everything is in workers' comp.
Of course.
So you can't just take off on your own and say, okay, this is what I'm going to do.
Exactly.
Now, in the early stages of a claim, if they refuse to provide you any care whatsoever, there is an opportunity for what's called self-help, but you really need to be talking to a lawyer about all that, because
before you dive into it.
Right. Yes. That has to be set up in a way so that they are given notice, the opportunity to get you a doctor. They refuse to do that. And after 5 days, then you would have an opportunity to get essentially what would be kind of almost an emergency type care.
Right.
But short of that, and this happens quite frequently, say, you're really needing even something the doctor themselves recommends. They might not, maybe they recommend an MRI and they don't, or sometimes
they're taking months and months to authorize it.
So what ends up happening then is what has to happen is we have to file a petition for benefits in the workers' comp court, which is kind of an administrative court system. And basically, ultimately, if they don't eventually agree to it, there's actually a hearing before a judge.
Right.
Usually in those situations, eventually we get them to agree to it. But the mechanism to get you into a doctor is actually one that requires an order from that judge if they don't agree. Yeah,
exactly. And so to answer the question in the comments, it would not be advisable to go on your own. The best option would be to reach out to a workers' compensation attorney like ourselves so that we can kind of walk you through that process. Because if you start treating on your own, you're going to have some issues with payment of those bills or the admissibility of those opinions and such. So I wanted to talk about that since the question was already brought up. With those opinions, let's say, Jake did start going and treating on his own and building a case of his medical with his own provider. Would that medical opinion be admissible in the work comp case?
No, it would not. The system is set up so that under the actual law, the only opinions that can be considered by the judge are from the authorized workers' comp doctors. And then there is a mechanism to have what's called an independent medical evaluation.
Right.
That is utilized in certain situations where there's a difference of opinion in the usually with the medical providers. But bottom line, none of the treatment that you get is anything that the judge will be able to consider in terms of the medical opinion. Sometimes it can have some help in terms of the factual basis, but in this context that Jake was talking about, you want to go see another doctor and they're saying, well, you need a surgery. Well, workers' comp will pay no attention to that.
So what, basically? So that's a good question, and hopefully that answered it. The lines are open. We are taking your calls live on the air, but if you'd like to do like Jake did and leave a comment on Facebook or YouTube for us, you can certainly do that as well. But of course, the call-in number is 727-441-3000. You can certainly call us this evening. If you have any questions regarding workers' comp or any other personal injury issue, of course, that's what we're touching on tonight. Before we take a break, I do want to ask another question about what you touched on just a second ago, actually, about the claim being denied. So obviously, there are situations where a person comes to us and nothing's been authorized. They're denying the claim in its entirety, and the person's hurt, they're injured, they need some sort of care during that process, and it's not always going to be immediately resolved. So what options do they have as far as medical care when the claim has been completely outright denied?
Well, they're, again, kind of limited, really. Yeah. So we do have situations where we file petitions to get a determination of what we call compensability. The claim itself should be covered under workers' comp.
Right.
In order to have a medical opinion that will be something that workers' comp and that the judge would have to look at, we have to go through this process of getting an independent medical evaluation.
Right.
And those are accomplished. Sometimes you can accomplish them through getting a small advance from the workers' comp carrier under provisions of the law. Sometimes we'll have situations where people have health insurance and we can work to arrange an evaluation. But it must be an independent medical evaluation under the particular law. And so this is not a doctor that can treat you. They have to evaluate you.
Exactly.
And then,
so it can't be one of your own established treating physicians.
Right. Yeah. So unless the other side agrees, but generally speaking, they're not going to,
Right.
Sometimes we slip that by. But basically what you're looking at, it's an evaluation so that there is evidence that the court would have to consider. And then, that's So you're kind of in a very difficult spot. So if you had other avenues of treatment, yes, you could do that, but none of that would be considered as a part of the workers' comp.
Right. And that's what you want. You want it to be considered.
Yeah, you must have this independent medical evaluation so that there is something that you could ultimately prevail on before the court.
Right. So before we take our break, what would you recommend or suggest to a person who says they've denied my claim and I'm not getting the medical care that I need and it's their fault, it's their own negligence? Why can't I just sue them and just sue my employer because they're the reason why I got hurt? They didn't have safety standards in place or whatever the case may be.
Right. And so, again, I hate to be the bearer of bad news, but the workers' comp system was set up in the early 1900s with the idea that it would make it very streamlined and simple for the employee. You would not have to prove fault because a lot of times it really isn't the employer's fault, but sometimes it is.
Yes.
Sometimes it's just something that occurred, but sometimes it's the employer's fault. And the law, unfortunately, protects them completely from any claim of negligence. I mean, it really, there are very limited circumstances, almost practically none, in which you would ever be able to bring a claim directly against the employer. Now, if there was some third party, say you're on a job site and there's something that causes you to slip or fall, and the owner of that premise could be responsible. So there are circumstances where you can bring claims against people outside of your employer. And that's pretty common, actually, that we have see that a lot, and obviously that's kind of a better option, really, because then we fight for the workers' compensation benefits, but you also have much broader benefits within the broader tort system.
Exactly.
Because, of course, workers' comp, we're fighting to get you medical care and then wage loss under the workers' comp system if you're unable to work or you're restricted in what you can do. But there's no pain and suffering. There's no consideration for how your life has changed, the things that are front and center. Really.
Sometimes the most important things, the ones that weigh heavily on and most individuals are the things that workers' comp will not, unfortunately, compensate for.
Yeah, they're not. Those are not a part of it because the theory was, that it was going to be this streamlined system. You could just get the care you need. But
expedite getting back to work,
but over time, they restricted the benefits more and more and more, and it really, So it's not that it doesn't work probably a lot of the time, but most people going through the system are going to find they have issues along the way. And it's a good idea to have input on that. And we'll have a lot of cases where people want that, just to have the situation monitored because they don't really know, what to expect. Yeah.
Exactly. And so you brought up two good points, and I want to touch on them before we take the break so that we can finish this thought. So with suing your employer, is there any possible way that can be done, right? So I understand that if there's almost intentional acts, which are very, very rare, of some kind, again, from the employer against the injured worker, that there may be some avenue there, right?
So, but it's going to be a very rare case because it literally has to be something that is intentional and virtually certain, I think is the language,
right?
In injury, right? And so if you have, I was involved many years ago in helping on one of the cases at the firm, and it was just tragic. A woman lost a portion of her arm. She was doing, I think she was working for like Tropicana type thing or something, but it's, there was nothing, it was something we felt strongly that you virtually certain were going to have an injury because they had dismantled a certain safety. Yeah, it was a safety feature that, that they were allowing not to be present. But and we litigated that case through up the appellate level and stuff. And unfortunately, the case law is very strong.
Very,
very strong. So you're literally going to be talking about something that was intentional and that there's just virtually no doubt was going to lead to injury. Right. And so now we do review cases, obviously. And so if something outrageous occurs, it is important to have it reviewed, but it's very, very limited that you're going to be able to bring a claim directly like that.
And that's what I wanted to drive home for the listeners so that you can understand that. Is it possible? Yes. Is it very rare? Yes. It is. Certain circumstances has to be extremely egregious. And as Lori said, it's good to get it reviewed just to make sure you have an understanding of the facts and whether your case would qualify for such a thing. But understanding that the answer to that question is generally no. The answer is usually you cannot sue your employer directly for negligence. But with that being said, I want to also highlight the point that you made very well about third-party claims. So what you always, I would say, want to look at whenever you're hurt on the job and you believe there's some negligence, understanding who caused it or where you are at the time. Are you on someone else's property? Is some other entity other than your own employer responsible for the injury that you have sustained? The fact that you're working on the job is going to obviously qualify you for the workers' comp benefits. But if some other third party who's not your employer is the reason for the injury, then that's a totally separate claim, like Lori said, right?
And we will always investigate all of those aspects in any kind of a serious injury.
Exactly. And that brings me back to my original point. You want to go to an attorney who does it all. And you can find us at voiceoftheinjured.com. I think that's a good spot for us to go ahead and take our break. As we get ready to go to commercial, as you know, the lines are still open. It is 727-441-3000. We're going to take a short 2-minute break, and then we'll come back with more discussion about Florida workers' compensation.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, Call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
We are back from our commercial break. Thank you for continuing to tune in to FLA Law Live on the radio. Hopefully you've been listening since 5. We are here with Lori Robinson from our office, and she and I have been talking about workers' compensation tonight. That is the topic for the evening, but of course we are here to answer your questions on all things personal injury, civil litigation, trial-based, and any other legal matters you may have. You want to call in and get your questions answered over the air. The number is 727-441-3000. We're also streaming live on Facebook. We're in the studio here to answer your questions. Just drop them in the comment section and we'll answer those right over the air. The same with YouTube. Hopefully you're checking out our YouTube channel and you can do the same over there and ask questions and we'll answer them live on the air. So jumping back into the conversation about workers' compensation, we've touched on quite a bit. But I mentioned it earlier in the show, but I want to go back to it because there's obviously a lot of overlap when people are working and they're driving a vehicle and they're involved in a car accident while in the course and scope of their employment. And so when they're hurt in a car accident on the job, and workers' compensation starts to provide the medical care and sends them to a provider that they may or may not be happy with, as we've already gotten into a bit. There's PIP and there's auto on the other side of the claim. And so how would you explain that to a potential new client as far as the workers' comp side of things and the auto side of things there?
Right. So it does give you more options, which is good. But you're still, in terms of the workers' comp, going to be in a situation where you're going to want to follow with workers' comp doctors in most situations. Now, there are times when clients don't want to, you know, and depending on the situation. And with it, if you've been in an auto accident, you know, under the Florida no-fault law, the PIP or personal injury protection benefits are available, and you can go see whatever doctor you want, and then you will have the ability to have the bills paid 80% up to the $10,000 with some other wrinkles along the way here. But and that does give you a good option. And sometimes people will actually do a little of both,
right?
You know, where you maintain the workers' comp treatment, but you would, for example, be able to see a chiropractor under your personal injury protection.
Which you typically wouldn't have that benefit under workers' comp.
Not usually. I mean, you know, they might have a little limited of it, but not usually, you know. So you'd have some options there to maybe get some more supportive care that people would often want to take advantage of. But there are going to be two things that are going to be looked at, you know, basically, because part of what happens when you're treating with workers' comp, if you are most likely looking at a situation where you like your job, you've been there a while, you're not really going to be interested in settling your workers' comp claim. Exactly. Which almost always would involve resigning from your job. Not always, but almost always, due to the insurance requirements usually. But, you know, if you're going to be staying with your employer, then you're going to want to probably preserve the workers' comp claim so that if, God forbid, you do need some additional treatment, you have those options. But you would have more flexibility in going ahead and basically treating with the idea of getting your care through the auto accident claim.
Exactly.
And again, that's something that, you know, you want guidance on, which again is a reason why it's very helpful to have the same lawyer basically helping you.
Exactly right. Because you could be in a situation where you have been injured due to the fault of some other driver, and that person has very limited bodily injury coverage, and your injuries are significant, and you need to be able to continue your treatment above and beyond what that person's, bodily injury policy might be. If they're only limited at 10,000, but you've got much more you need to do medically, then it may be beneficial to keep that workers' compensation claim open and continue your care and your treatment through that, even after you've pursued and resolved the claim against the other driver.
Right. Because it goes, workers' comp is responsible for your care, in theory, for your life, so long as you treat at least once a year or receive a benefit once a year. And so we have quite a few clients that we monitor their situation. They've been on workers' comp for literally decades, basically, and they, for a variety of reasons, don't necessarily want to settle their claim, but they continue to keep that claim open.
Exactly.
And then they have the option for the medical care, and they also have the option to consider at some point, if they want to just do a lump sum settlement if they want to.
Exactly. And it's also, I think, good to point out that workers' compensation will still have a lien on the auto claim or the third party claim for treatment that they provide as a result of that injury, assuming there's some sort of settlement or some recovery made against that third party. So I don't want it presented as if it's all free and clear. You don't have to reimburse. There is a right of reimbursement.
Yeah, and that is something, because workers' comp would have, what we call a right of subrogation. So if you receive a settlement, then they'd be entitled to something back. It works out to be a negotiation, and it's not like 100%. And often it's a pretty good incentive on the auto side for the defense to look at the claim, because a part of what drives the value of an accident case, an automobile accident case, is going to be what are the medical expenses that have been incurred that they would be responsible for on the other side, which sort of tends to also support the significance of the injury. If you've had a lot of treatment, I think most people would draw the inference and the conclusion that you were injured pretty badly.
Exactly right. And so I guess the key takeaway with that is you absolutely can pursue both. You can pursue one or the other, or you could sue them together simultaneously. And so the benefits don't necessarily have to choose, between one or the other. And like Lori said, it's best to find an attorney who can manage both claims and then assist you, so that if you do choose to keep that workers' compensation case open for life, then it's being properly monitored. I've, like you said, we've had clients who we've monitored for years. Clients that move out of the state, they're no longer even with that employer. I had one client, and I can't remember the name now because it was such a remote island. She moved to some very remote place. I want to say it was in the Caribbean. There were no treating physicians. They literally had to fly her to a mainland in order to get her treatment. And of course, it was a nightmare for the work comp carrier. It was like on a certain day, and only certain days of the week that planes were even coming in and out. So it was quite a journey, but she had that entitlement.
Yes.
The injury happened while she was on the job, and she worked for a place in Florida. Then she ended up moving away to this remote place. I think maybe her husband had a job there or something. And they still had to provide the care. They had to provide the transportation. They had to do all of those things. And so, as you can imagine, they were probably quite happy when the case did end up resolving.
Yes.
But yes, so that's essentially what you want, is an attorney who can monitor all those things and guide you in the proper ways when there are multiple claims that are going on, simultaneously. Now, let's jump back into the conversation. You mentioned it briefly before the break about the role of a judge or the trial situation when you go to a hearing. It's not necessarily a trial, right? What exactly is that process within the workers' comp system when you litigate? Do you get in front of a jury, or how does that work?
No jury. It would be what we call a bench trial, actually, but it's really they call it the final hearing. And so it's a judge, a workers' comp judge who's been appointed. It's like he or she is essentially admitted what they call an administrative law judge, and they work within the Department of DOAH, whatever, it's workers' comp. And so what you have, it's testimony can be offered in workers' comp. Quite a bit of it is offered in a somewhat more informal way. So there may be depositions that are offered. No doctor will come to testify, though in theory they could, but that's not how it's handled. You'll have depositions will be taken of the treating physicians.
Right.
If there was an independent medical evaluation, there'd be a deposition of that person.
Correct.
But typically, in most situations, it would be our client, the claimant, who would offer testimony.
Right.
Yeah, and pretty much that would be probably the live testimony, and then most of it will be argument of counsel. We submit trial memoranda and things of that nature, and then the judge takes it all under consideration and will issue an opinion on the issue. But of course, in workers' comp, it's always going to be very narrow.
Exactly.
And it's really going to be, are they required to authorize this doctor or the care that this doctor has recommended?
Correct.
Or, there will be often disputes about the wages and
benefits
that
of
kind of
indemnity.
thing,
Yeah.
that sort of thing. And so, and actually very few cases go to final hearing. I mean, it's, and it seems
That's true.
even fewer.
The same
now.
with jury trials.
It's true. That's true. Used to be a lot more, but it's gotten less and less. But most times in workers' comp, not always. I mean, I've certainly had a few hearings within the last couple of years there, but it's usually those cases will have eventually resolved. Basically, the issue will be resolved or whatever. Because when you think about it, I mean, obviously, if a doctor is recommending treatment, how is it possible that they're not going to ultimately authorize that? And yet they will slow walk that and ignore it.
Yeah.
I mean, we had one recently where a doctor an orthopedist had recommended injections, epidural steroid injections, and then there's some dispute, but apparently the carrier's position is that the pain management, there needed to be a pain management doctor. Okay, fine. Then went to the pain management doctor who recommended the injections. And then months and months and months went by when they, of course, didn't provide them. Now their position is, well, that prescription is stale. We will authorize them, but you need to go back and see that doctor.
Oh, gosh. And get the doctor to say it again.
The claimant has had it. It's like, what? What is this? I mean, but that's
those are the
unfortunately.
hoops and the hurdles we've talked about. So.
Right.
We have another good question on our Facebook Live, and this question is pertaining to the auto conversation we were having from Phyllis. Phyllis wants to know, if you were in an auto accident in the scope of your job and you don't want to quit working, how would you go about filing a claim on the person that hit you and continue to keep working?
Right. So actually, a workers' comp claim and a personal injury claim arising out of an automobile accident are entirely separate. Yeah, they're totally different. So the only time that you get involved with having to leave your job in connection with any kind of a settlement is if you settle a workers' comp claim. It is almost always the requirement of the insurance carrier that you resign from your position. I mean, they don't want word spreading about settlements or whatever their reasons are. Occasionally, a person that has a very long work history will be able to make a settlement of some issue where that won't occur. In fact, but if you're going to have a lump sum settlement, generally that's what would happen. But the auto accident is a totally different matter.
It is.
That is handled. The employer has no role in that at all. And doesn't have a reason to be concerned about it. So
exactly.
So that would proceed normally.
Right. And so you could pursue that auto claim, Phyllis, without ever having to leave or resign from your job. Now, if that auto injury causes you to be out of work, then there are certain avenues where you should be getting paid for that time while you're out, but not necessarily having to resign or quit your position.
Right. So under the workers' comp law, you would be entitled, if your doctor has either taken you out of work completely or has given you work restrictions that your employer isn't able to meet.
Exactly.
Yeah, so that you're not working. So in those scenarios, the law dictates what you are entitled to receive in terms of what they call indemnity benefits.
Exactly.
Yeah.
And so if it's a situation, and I'm obviously reading more into the question than what you necessarily asked, Phyllis, but if it's a situation where you just don't want to get your employer involved, you like your job, you don't want to make a workers' compensation claim, that is your choice. That is your right if you choose. You just want to pursue the at-fault driver, want to make that claim against them. I don't really want to get into the workers' comp side of things, which, again, as Lori and I have said, you do have both of those benefits and are entitled to both. But if that's what you elect, you can absolutely do that. Mm-hmm. And so that was what you were asking. Hopefully we've touched on all the different scenarios that help you understand. Great question, Phyllis. So going back to just what we were talking about just before her question about the final hearing process and going to that final hearing and the JCC awarding benefits, can you get a money damages or a lump sum award from a workers' compensation judge?
And of course, the answer is no. Mm-hmm. And that is the one thing that is the hardest for people to understand.
Yes.
I guess people have a general understanding of, a personal injury claim and the settlements. Mm-hmm. And so they just assume that would be possible, but in workers' comp. But the judge can only decide an actual issue. So you might be owed a period of wages if that was the situation, and the judge could grant or deny that benefit, but the judge can never make an overall award.
Exactly.
Even though, and it's so frustrating for people because, we'll have mediation, settlement conferences, just like you do in any other litigation setting. Mm-hmm. And the person will have a great deal of difficulty appreciating that it's not you can't go to the judge and think you're going to get a different result. In fact, all that can ever happen is your workers' comp claim continues, or you reach some sort of a negotiated settlement with the employer carrier insurance company.
Yes, that's a famous line from one of our mediators that we use often in workers' comp. She's like, you get to stay in the system, or you take the offer. You have to decide which one stinks.
Get a divorce, right, or something like that.
Yeah, they're both crap. Which one stinks less to you? So,
right.
That's kind of how it is, unfortunately. So it's not one of those situations where the inclination is, well, this offer is low. It doesn't seem fair. So let's take it to trial. That's not the option, unfortunately.
Now, it might be that it's not the right time to settle.
Right.
There could, and that's where legal advice comes in.
Exactly. And there can be things that you learn at a mediation that help you understand how to increase the value of that offer. But taking it to a judge and getting an award is unfortunately not one of those options. Right. Yeah. And so you touched on it again, but I want to make sure people understand if you do settle and you get that lump sum, can you continue on with the claim?
No. So and that would be generally true in any settlement scenario of any kind of personal injury claim, but you're done. Yeah. So once you make a lump sum settlement, that's it.
Yeah. And I get surprised at how many people ask that. And they're like, well, can I take that $10K or that whatever and still go back to the doctor and continue my treatment? Unfortunately, that is not an option. It's done. Like you said, it's a divorce. It's over. You can't keep going back over to their house and hanging out. And it's over.
When it's time to settle, you probably don't want to go back over to their house.
Exactly. It's the relationship is over. No more treating physicians, no more paychecks. It's one lump sum, and it is a settlement, a complete settlement. And with that being said, we are winding down on the show, but I want to make one last point when it comes to the lump sum settlement, and you've already touched on it. But like you said, once you settle, most employers want you to resign, right?
Mm-hmm. That is correct.
And so a lot of people don't realize that I have to leave my job if I settle my workman's comp case. So that's something you want to make sure you are prepared to do if you are wanting to settle your case. It's been a great show, Lori.
Yes, always enjoyable.
All about workers' compensation.
There's so much.
You've been great as always. To our listeners, we'll be back here on Tuesday at 5 p.m. answering your questions live on the air with FLA Law, live on the radio. See you next Tuesday.